A very well welcome to the second of a series of SCCA webinars on mediation. This week we will be focusing on mediation as a solution for commercial disputes under the COVID-19 pandemic. My name is Christian Alberti. I am the Chief of ADR and General Counsel at the SCCA, and with me are in alphabetical order, Mark Appel. He is an international mediator, arbitrator, trainer, and consultant with ARP-DB Chambers in London. Mark is also an honorary director of the International Mediation Institute, and since 2016 has been the chair of the IMI's Investor State Mediation Task Force. Mark, are you with us?
I am, Chris. Thanks very much.
Welcome to this webinar. The next is James McPherson. James is an international arbitrator and a mediator specialist with over 25 years of experience resolving commercial disputes and training professionals. He's also co-founder and former CEO of the BCDR AAA, board member of the Oman Arbitration Center, and a special counsel and project leader at the SCCA. James, are you with us? Greetings to Canada. Our next speaker is Richard Emack. He's the founder and former senior vice president of the ICDR, the International Center for Dispute Resolution, which is the international division of the American Arbitration Association. He has over 40 years of experience as mediator, arbitrator, and trainer around the world. Greetings to the United States. Are you with us, Richard?
Greetings, and I'm happy to be here from across the ocean.
Wonderful, thank you. Last but not least, we have Paul Rose from London. He is a mediator, experienced in over 150 cases. Perhaps most interestingly, there was one exit case among them. He's also an experienced chartered arbitrator, director of the UK's SCMA, and a member of the advisory board of the Dubai Mediation Center. And last but not least, a member of ARP-DB Chambers. Thank you all for joining me today and taking the time out of your busy schedules. Many thanks go also to all attendees for joining us today, despite the late or perhaps also early hour, wherever you may be right now. Then again, as most of us will likely agree, that time is even more relative than ever these days. Our topic today comes at a time when businesses came to terms with the fact that the disruption caused by COVID-19 is here to stay much longer than we originally expected. And virtual meetings will slowly come to the norm, if not already. So of course, that comes with many challenges. We hope to address a few of these by dipping into the vast experience of our speakers, bringing to the virtual table, having done hundreds of mediations around the globe. As for structure, we would like to start with short presentations by our speakers, followed by discussions. We will then move on to a more general discussion and allow some time at the end to answer questions from the audience. To our audience, you may post your questions on the chat board, the Q&A board, or ask any live questions at the end. This is a 90-minute session. We will record it and publish on our website later this week. So let's get started. Mark, I believe you will kick us off today with your thoughts on mediation in the era of COVID-19.
Thanks very much, Chris. It would be hard to overstate the impact of COVID-19 on our personal and professional lives. I think this weekend I saw 3 million cases to date globally, 250,000 deaths. We haven't seen this kind of a pandemic in 100 years, so it's remarkable. Needless to say, it's impacted everything, how we communicate. The fact that we're on this program this way is part of it. This is how we talk with our partners. It's even how we talk with our children. You know, things have just changed radically. And needless to say, perhaps the impact on global commerce has been devastating. Delay and disruption claims, total collapse of supply chains, infrastructure projects come to a halt, buy-sell agreements unfulfilled on a massive scale, unemployment not seen since the 1930s. It's been remarkable. All of us see one outcome, and that is business insolvency on a level we've never seen before. So that's coming as well. So the question then is, why this webinar and why mediation, now? And it's easy enough. particularly for those of you who've had the privilege of working in the mediation process. Mediation works particularly well in where there is a commercial uncertainty. And if there was ever commercial uncertainty, it's now. How is my partner, my seller, my employee going to be tomorrow, let alone 6 months from now? And uncertainty even in terms of outcomes. If I have a claim, a business claim, where do I go? Can I go to court? Is the court even open? What do I do? So uncertainty. Even in the law, do you want to be the first party? And Paul's going to talk about this some. Do you really want to be the first person to take an act of God clause in your contract to a court or to an arbitrator? So real uncertainty. And mediation also provides a solution, particularly when money is tight. And if there was, again, ever a time when money is tight, cash flow issues exist all over the world, and delay doesn't help cash flow. People need access to money. Banks are doing what they can, but settlement is you know, all of us have this expression in every language. You can't get blood from a stone. You know, so find a solution, find one today. Mediation is a flexible process that allows you to do just that, to figure out business solutions, commercial solutions when those commercial problems crop up and need to be solved soon. You can negotiate workarounds. You can negotiate remedies. Those things aren't available from a judge. They're not available from an arbitrator. Think of yourself business solutions first. So this is the time. And I guess I want to say this is also a time for policymakers. Access to justice is an important issue always, but it is particularly important now. And whether you are a justice ministry, a courthouse, an arbitral center, mediation center, this is really the time to step up and to provide systems and assistance to parties who need a forum. And, you know, we're looking at one. This is how we mediators spend our time now. We're on camera. But you know what? It works. And I suspect this process is going to accelerate lots of things that have already started. Changes with us. We can do this. Thanks for your time.
Thank you very much, Marco, for your insights. You mentioned in your presentation, your remarks about mediated business solutions and cash flow issues, disruptions because of that. Do you have any example for this?
And some of you may have seen this already. I mentioned supply chain breakdowns. Manufacturers now are increasingly dependent on high-value suppliers. They don't have a lot of them. They're likely to have one. You know, this is the outfit that makes this part, and I need them to be to provide me with materials. By way of example, the problem with masks and medical equipment around the world occurred in part because suppliers were economically couldn't provide what they needed to. They couldn't get up to speed. They had economic issues themselves. So manufacturers in this kind of an environment are already using the negotiation process and mediation to do interesting commercial solutions. So I'm going to take a economic piece of my supplier. I'm gonna do what banks do. I'm gonna provide capital to allow them to continue doing business. And you know what? I might even buy them. I might make them part of my own company if that's what it takes to make sure that my supply chain is uninterrupted. So, and those kinds of solutions are the kinds of business solutions that happen in mediation.
Thank you very much, Mark. Anyone else has made any experiences with cash flow issues, billing, non-payment issues in the mediation realm? Paul? I think you're still muted.
I think I'm unmuted now, thank you. I certainly have. I think it's very important because the world seems to have come to a stop. One can't get hold of clients, one can't get hold of professional advisors, and clients are not paying. They're hiding, as it were, behind this crisis. And it really has affected cash flow all around the globe, never mind any particular country. That's been my experience so far.
Thank you very much, Paul. Anyone else has any experiences with billing or non-payment issues, cash flow, or any thing that has come across your desk in recent times? On that, I'll move on. James?
I was just going to say that in the past, particularly in the GCC, a lot of companies have been loath to take action against state-owned entities or very large family-owned entities because the relationships that underpin them are so precious and took such a great deal of effort to develop and maintain over the years. So when there have been dips in the price of oil or other geopolitical issues over the years, people have been loath, as I said, to take legal action. That said, these transactions and these relationships are infinitely internationalized and there are a lot more people at the table. So as things have gotten more complicated, that hasn't changed the fact that government players and large family conglomerates are the big players in the GCC. So I think people will still want to maintain those relationships. And I think if you want to maintain relationships, there's nothing more effective than a discreet mediation, as opposed to a publicly filed lawsuit or even invoking an arbitration clause too early. So I think that this is a real opportunity for the people on this call and others to actually get engaged with people and direct them to the mediation solution.
Very true. Thank you very much, James. Before we move on to Richard, I have one more question perhaps for Mark. You mentioned briefly policymakers. Are you aware of any recent governmental initiatives to increase access to justice for parties impacted by COVID-19?
Yeah, actually I am. I can give you two, and I don't know where one is, but I will tell you in Malaysia right now, they're looking at a COVID response. It's likely to involve online dispute resolution. I can, I'm of course going to leave my colleagues at the SCCA to talk about what you're doing, and I know you're doing things in this regard as well. I also just read that our colleague Teresa Chang, who most of us know as an arbitrator, but now the Minister of Justice in Hong Kong, has just instituted a online mediation arbitration program for claims under 500,000. And that's part of, and listen to this, that's part of Hong Kong's Mediate First policy. So that's a policymaker stepping up and saying, this is what we need to do. This is part of better solutions that are better for our state and better for business, and we're going to support it. Oh, and by the way, $200 to access that process. So the state is underwriting the costs. That's, you know, you need to talk when you're talking about states, you really need to talk about incentives. There's a great book called Nudge, you know, where the state, by adding incentives or disincentives, can get people to do things that they should be doing anyway.
Thank you very much, Mark. We also have one participant mentioning that in Indonesia, some foreign funded projects have been suspended. Quite dramatic there as well. This has already initiated claims notices from contractors and consultants. So interesting to know. So thank you for this quick note from our audience. Let's move on real quick to Richard. We have, I guess, a somewhat interactive presentation coming from your end. If I understand you correctly, you will give us basically virtual mediator opening statement demo and other topics that fall in line with that, and also how mediation looks like. Richard?
Yes, we just wanted to do a summary presentation of what the opening statement, the introduction by the mediator would look like. And so with that, I will jump in. I am Richard Neymark. I was appointed. Mark and Paul, I understand that you are two parties who have an issue, and I commend you for attending today, which indicates some commitment to at least exploring your issues in this process and working toward a settlement. So thank you for that. I have considerable experience in mediation and mediator training. You have my CVs. I think there's no point in going further into this. My role is to be useful to you in facilitating the discussion, but the discussion is yours. Mediation is essentially an enhanced negotiation, and hopefully I will serve as an enhancement and not a barrier to effective discussion. Your job is to reach agreement, to move toward a settlement, to find issues that are of importance to each of you, and perhaps areas where there is overlap, which can build towards a potential settlement between the parties. And that's the ultimate goal. As I said, my goal is to help facilitate the discussion. The mediation is yours. You own the mediation. I will say I own the process. So you will have to indulge me from time to time in timing, in sequencing things, in scheduling, and in setting the agenda. And I will monitor the process and act as a sounding board for each of you. What I hope you will both do is bring forth the issues of importance to you, the issues that must be addressed to bring about a settlement, the things that matter most in order for you to move on with your life and your business. I would also add that this is a great opportunity in mediation to move forward in your dispute. And I note this may be the last opportunity that you have to control the outcome in the case. If you don't, normally a court or an arbitrator will decide the outcome of the case. And with the current shutdown of the world economy and court systems around the world, I think that you could wait a very, very long time. So I want you to realize what you have done by choosing mediation is empowering yourselves to move forward. And I commend you for that as well. Please note also that most cases that proceed to mediation make great progress, and most of them reach a settlement. So I'm sure we will get there as well. So the ultimate goal is to have a completed agreement and a signed agreement, and we will work on the mechanisms for doing that online and offline as well. So what we need to do at this point is have each party identify themselves, and we need to establish that we have complete authority to settle the case here in this virtual room at this time. Mark, could you proceed?
Absolutely. So I'm here. I have authority on behalf of my company, and we came here in good faith to negotiate this matter and hopefully reach a conclusion. Thanks for your assistance.
Thank you. Paul? You need to unmute.
Yes, good evening. Am I unmuted now?
Yes, you are.
Good evening from London. Yes, indeed. I represent my company, and we do have authority to settle as such. The problem is that I've got third-party insurance, and I have to speak to my insurers.
Mark, do you have a response?
Well, only that I'm surprised, you know, I wish we would have dealt with this earlier. What you're telling me is you really don't have authority, Paul. And so I guess what I would want to be sure of is that we do have authority in the room. I'd also like to know where that authority is, and I'd like to know who that authority is. I am concerned about issues like confidentiality, which I understand apply to this process. And I'd like to know who's participating. But I certainly don't want to proceed without the requisite authority present.
Well,
go ahead, Paul.
Well, I'm a little bit concerned about releasing who our third-party funder is because they want to remain confidential. However, what I am prepared to do is make the necessary telephone call in order to obtain that authority, and I'm very happy to make that call before the mediator, who I trust to be completely impartial, so that the mediator will know that the third-party insurer does have that authority and that this settlement, if we reach a settlement, goes through. But they have to sanction it. How's that?
How is that?
What I want to make sure is that we have authority to pursue, to settle. You know, I don't want to waste my time, and I don't think you want to waste yours. So, Mr. Mediator, if you want to get on the phone and you tell me that we've got requisite authority, I'm prepared to go forward.
Well, I expect you to trust me on this. I will make that telephone call. We're not here to waste time. We're here to try and find a suitable settlement. It would be better all round if this dispute were put behind us, because we do have a business relationship. I recognize that, and my client recognizes it. I don't have the authority and position to reveal who the third-party funder is, but I'm very happy to make the call in front of the mediator during a private caucus. Would you accept that?
Yeah, you said fine.
Okay, so just to summarize, our options at this point would be the apparent agreement we have here for Paul to make the call to the third party in front of myself and get assurance that he has authority to settle. Barring that, we could adjourn and reschedule at a future time when Paul is able to bring the third party in. Or we could proceed with an understanding of what the ratification process would be, absent having a third party here at the time. Or we could simply proceed today, see whatever progress we make, and then see what we can do afterwards. But it sounds like we have the workings of a way forward, and we'll proceed with that. So before we do so, let me just bring up a few more points about the process. Process is quite simple. It will work as we have just accomplished ourselves. Each will speak in turn at my request, and I ask that when each one speaks, the other not interrupt, and then you will have a chance to respond. And then we'll move to dialogue, direct dialogue. Traditionally, in traditional in-person mediation, there's something called a caucus, which is a confidential sidebar discussion with the mediator and each of the parties separately. These are confidential. They're done to explore the issues of importance to that party and also to help create proposals for that party to present to the other party and encourage the movement forward. However, it's a difficult process, particularly online. Think about it. One of you will be engaged with me for a certain time, and we'll be having our private confidential discussion in a secure setting, and the other will sit and wait. So we will try to put 15-minute time limits on these caucuses. If we find they go longer than that, I will adjourn the caucusing process and talk to both of you about whether we want to do separate asynchronous caucuses at different times and then get back together for a joint session, or how you choose to proceed. That's just to let you know what the process will be. And I think with that, we will move forward. So Chris, I think we've done the outline of an opening statement.
Thank you very much, gentlemen, for this very interesting presentation. Of course, authority is absolutely key in the room in order to even have a settlement agreement coming out of that. Richard, to what extent would you recommend lawyers and clients to prepare themselves for the situation? We heard you as the mediator right now. To what extent would you give any advice to a lawyer or a client to prepare themselves before they walk into this, aside from getting authority, of course?
Well, first I would say take a deep breath. pause. Usually by the time parties are talking about getting ready for a mediation, they've already built up a head of steam. There's a lot of pressure in the case. So I would say pause, take a deep breath. It may sound a little simplistic, but I think it's important to be poised enough to engage in the mediation. Typically, the problem with some mediations is the parties believe they have to do extensive preparation, as you might in preparing for trial. Yes, there should be some preparation. Assemble the relevant documents, certainly any contracts or agreements between the parties. Any relevant correspondence. This is, again, not a game of overkill, but just the pithy, the core, the important issues which may be pivotal to an understanding. And a timeline, as you see it, if that is relevant to the facts of the case. Most of all, I think assemble two things. They're both essentially opposite images of the same thing. And that is the issues that you think are most important. I'm not talking about position papers. I'm talking about the issues that are driving the pressure in the dispute. For yourself, and then if you're really good, you know, they say the best negotiators are the ones who anticipate the other side's issues. So I would encourage you, after taking a deep breath, put yourself in the other side's shoes and think about what they're going to be demanding of you, and begin to think about where we could have some overlap of needs. Okay.
So it sounds like being a good chess player is not a bad idea after all, to anticipate the other side's arguments and find also, you know, common ground for solutions and keep the head open. Any final comments on this section, gentlemen, before we move on to the next speaker?
Yeah, quickly, I just want to second what Richard said about preparing not just your case, but theirs. If you're the lawyer, you really want to know what the other side is, or the other parties are thinking, and what their needs are, and what their interests are. This is an opportunity. Remember, I talked about commercial, you know, business solutions. If you can get past, and this is just classic sort of getting to yes negotiation, you know, theory. If you can understand their interests as well as your own, you're far better prepared to sort of come up with options for settlements that work under the circumstances.
There was also the issue raised about unrepresented parties. And one of the things about that is when you get to the end of things, they may reach a resolution, and they should be prepared, as in traditional mediation, to retain independent counsel to review the thing. Although this is a virtual mediation, there could be some efficacy or utility in actually retaining a lawyer to very quickly spend a few hours reviewing a settlement agreement, not to reopen it, but to ensure that it's complete and otherwise. But we'll get to that a little later.
Yeah. What's the view in London, Paul?
I'd like to come in on what Mark has said. And one of the most important things I think a counsel should be doing is actually exploring the other side's needs, because what counsel should really be looking for are those Pareto circles. Where are the common interests? Where the common interests lie, you don't need to negotiate. It's where you expand on those to say, well, look, how can I push out my boundaries in order to accommodate yours? And that's when you get the Pareto circles, if I can put it like that. And I can see Mark is smiling and nodding because he knows where I'm coming from here. When you get the overlapping Pareto circles getting closer and closer together until you finally reach an agreement. Now, if counsel can explore what the other side is looking for very early on in the process, that would really help the mediation to come along. Thank you.
Thank you very much, gentlemen. A quick note to the many comments that are coming in right now through the Q&A section as well as through the webinar chat. We have a couple of those topics that you have asked about coming up very shortly, so that's the one reason why we will not go into those questions right away. And second, we will here and there pick some of those questions and build them into my questions, but we will have enough time at the end to really go through your questions to the extent time allows. We have reserved some time for a Q&A at the end, so we'll make sure that we get all good questions in as well, to the extent we can allow for it. Paul, you're next on our list to talk a little about the impact on the process now, given to COVID, and what is the most effective role of a lawyer? So picking up on that issue that I mentioned earlier, what is a lawyer actually supposed to do? And what are the issues, by the way, and what has COVID-19 done to us?
Well, that's a very good question. I think it's forced us to reconsider how we meet, how we conduct business, and what is, and I'm going to come on to this fairly quickly, a foreseeable event. On that basis, can I concentrate just a little bit on what is a foreseeable event? Because I have to say hats off to the International Chamber of Commerce, because they have been very quick in rewriting their contract clauses. I actually have it here before me, and I'm sure all the attendees will be used to the ICC force majeure clause of 2003. Well, that's been altered. The basis of the clause, and I'm not here to give you a law lecture, the basis of the clause has not altered. It was the intention to afford a party, if I can read off, invoking a listed event to and not to afford that party too much protection, but definitely regarded as wrong for such a party simply to point it towards the mere occurrence of a listed event. Well, what are the listed events? Well, they were contained in the 2003 clause, but there's a new clause that's come out in March 2020, in which if you take a look at clause 3E, you will find that the ICC drafters have included both plague and epidemic. So they are force majeure elements which have now been brought in as a consequence of COVID-19. And I think that that's one of the major impacts. How can businesses contract and make provision for another COVID-19? Because I think that would have been an unforeseeable event. It certainly is considered to be now, but since we've experienced it, there is an argument that it would no longer be unforeseeable and that it would be foreseeable because we're experiencing it now. Who of the lawyers present would be sensible enough to ask their client, do you really want to be the first to take this before a court and spend all that money? And that's a question I'm going to throw out into the room. So that's what I think COVID-19 has really done to us. But you also ask, what is the impact on the process now? And what is the most effective role of a lawyer? Well, frankly, it's to have cognizance of confidentiality and, as you've seen in the role play, to be collaborative. Now, there are lawyers out there who are trained with respect, and I'm originally a chartered surveyor, they're trained not to be collaborative. But in fact, if you are collaborative, you will get through a mediation much faster, with less rancor, and also retain that relationship and not waste time and your client's money. So we then, I think, look at the impact on the process. And it's fairly obvious that COVID has confined people to isolation. So classic mediation meetings have become a thing of the past, and for cost reduction purposes may well remain so. I mean, if I could just touch very briefly, it's nothing to do with this particular webinar on arbitration, but I'll just mention it. It's normal in an arbitration to have an initial meeting done on the telephone just to find out what the parties are after. Now, it used to be just a telephone conference call. Now I think it's going to be a video call. And I think that's one of the impacts on the process. And so that takes us to what are the issues? I think the issues are virtual meetings, actually setting up the meeting, and the presence of disinterested people in one of the parties' rooms. You see, I've locked my door, but what happens if someone were to walk in? And you get interruptions online, telephones, doorbells. I'm getting emails coming through, which I'm just, clicking off. And then, of course, we have, as an issue, the force majeure clause under the CISG. And as I've mentioned, the ICC has brought out this new contract clause. But for those not familiar with the CISG, which is the United Nations Convention on the International Sale of Goods, Article 79 covers this. And basically, just to remind you all, as I'm sure you know, the obligor is relieved from an obligation to pay damages, and where it's obviously impossible, is relieved of the obligation to even perform. So that, I think, is the impact on the process. Christian.
And I think you mentioned something very important. Force majeure in some countries might be very well developed, in other countries less so. We had one quick comment from one of the audience saying that, for example, labor contracts present a big issue if force majeure per se is not well developed or not as defined or further developed as we know from other countries. So who's going to be the first one to put his money down or her money down to test this in the courts? Finding out that maybe you get a lot of question marks and have to go through the classical uphill battle in order to get some results out of this. Do you have any practical examples for that? I mean,
I do.
Force majeure?
Yeah, I do. Yeah, it's actually, there is a, people have been wonderful about sharing information lately. What a surprise on force majeure clauses and issues. And Richard, you'll get a kick out of this because it was actually an arbitration. Before AAAI-CDR, the dispute was between a seller and a buyer of chickens. And the seller was US and the buyer was Romanian. There was avian flu in Romania. The seller pleaded force majeure under CISG, Paul, no contract clause. The arbitrators looked at it, and it sounds real obvious. They said there was that the buyer offered a commercial workaround that the seller could have availed himself of and did not. And under those circumstances, they denied the seller their claim, and they had to pay up, presumably with money, although I suppose chickens was another choice. But one of the things I learned a long time ago from a friend of Richard's and mine, actually one of our teachers, is that everything is negotiable. People think that the law is sacrosanct, that you can negotiate facts, but not the law. Everything is negotiable.
I would say a dispute over chickens sounds like a foul dispute.
Indeed.
Excellent. Thank you very much, gentlemen. Before we move on with James, I have one more question perhaps for Paul. And just from a practical standpoint, because we heard already the mediator's opening statement, I wonder if you have any advice about a good lawyer opening statement and how it should look like.
Yes, I've actually got my own opening statement somewhere. He said searching for it. I think I've got it here. Thank you. Yeah, I would just go into the welcome, the familiarity with mediation, talking about the success rate, the fact that it's voluntary. I would really push the fact that it's confidential and that the mediator will not take anything out of a caucus room. I'm only going to refer to what happens in the UK. I hope no one minds because we have an international audience, quite a large one I can see. But in the UK, I always say that I cannot be called as a witness. And I've got a little sort of vignette for you. There was a pretty famous court case some time ago. I know both the people involved, not the parties, but counsel for one of the parties and the judge. I'm very friendly with both of them. And I've actually been threatened to be called as a witness because in each case, public funds were involved. So I always say that I can't be called as a witness unless there are public funds involved. And in any event, on the two ones with which I was threatened, one went away and the other, the judge concerned, was very unimpressed about the threat to call me as a witness and wouldn't entertain either the claimant's case, the complaining party's case, and certainly wouldn't entertain me being called. I would also talk about my role, which of course Richard's done. I would talk about time constraints because people do fall ill. I've had one person in a room complain at 4 o'clock that they hadn't eaten and then said that they were diabetic, to which I said, well, why didn't you tell me at 9 o'clock this morning? And we could have dealt with it. I asked her if there are any medical conditions, and of course, Richard's covered the point about courtesies and procedure, and the most important of all, authority to settle. Those are the bullet points that I would use.
So you have to be a mediator, nurse, multiple hats basically involved in the process, it sounds, at least in your cases.
Well, I wouldn't say nurse. I would say you've got to be pretty humane about this, because people do turn up and they do suffer from medical problems. And you really don't want somebody who says, I didn't take my heart tablets this morning and I've got palpitations. And you've got to, you've then got to call the emergency services. The wonderful thing about mediation is this wonderful mantra which I was taught, which was expect the unexpected, because anything goes and anything can happen. And as Mark has also said, in terms of, when he was referring, of course, to the chicken case, everything is negotiable. He's right. And that's the wonderful thing about mediation. You can negotiate anything. Whereas, of course, the major difference, but of course everybody knows this, is that in a court, you may not get what you could possibly negotiate privately. You may only get damages. And sometimes damages doesn't always cover it. Sometimes there's an apology required, there's a gift required, there's extra tickets required, anything as part of the negotiation process. There you go.
Chris, if I may, just to follow on Paul's very good comment about expect the unexpected. In fact, as a mediator and as a negotiator in the process, I'm looking for the unexpected. That is the fertile foundation of a settlement, of moving the parties. It's what has not come out up until that point. Good point, Paul.
Excellent. Thank you very much, gentlemen. Since it's still hot off the press here, I have seen one comment where a person stated that force majeure clause is already being tested in the context of hospitality and air travel industry, which is not surprising. Governmental restrictions, of course, such as curfews, have effectively closed those businesses in many areas. Definitely a hot area to look out for. Frustration, of course, being also highly in demand or debate right now. A lot of questions that we have seen so far, and again, we will pick questions at the end and go through these, but I also want to make sure that we cover some of them that kind of are right now in the works around virtual mediation, and this leads straight to the topic that James will be covering. We'll be talking about classic versus virtual mediation. No higher expectations in the sense that a lot of questions will actually deal with that, a very interesting topic. Many want to know what is actually the difference here. Is there any difference in the outcome? Does it affect the outcome? So we look forward to James and enlighten us, please, if virtual mediation is a good, bad thing, the same thing. What is it?
Thank you, Chris, and thank you all of you. Basically, I guess the question is, how is virtual mediation different from classic mediation? Now, obviously, there's the impact of technology, but before that is that context that Mark outlined in detail. Basically, everyone's got the same anxieties about economic issues and consequences, and unfortunately, they're both real and unrelenting at present. And when you throw in the social isolation, it can be quite brutal. And I think when we talk about this, you have to remember, you might be the first person they've seen that isn't a family member in a month. So there's going to be a certain edge, a certain energy, a certain something that has usually been missing from your previous mediations. I think you also have to remember that the things that make virtual mediation more challenging also make it more suitable, okay? So what I'd say is that mediators and parties need to take more seriously any and all aspects of what the parties are saying, because a lot of these things you were able to pick up through body cues, through various social interaction, even just meeting in the hallway before the session, all that doesn't exist. So it's just showtime. If any of you saw a great Foss film, you'll remember this line. So basically, what you've got is people who are there because it's the only option. Now that's the usual situation with classic mediation. Often people are in the room because this is the only venue that they can bring forward a set of issues. And I'm sure all of you have had mediations where you're mediating and you sometimes wonder if what has been brought forward or put in the summary brief bears any relationship to anything that the parties are talking about at this very moment. And that happens because there's a disconnect, which is normal and natural. So I would suggest that you have to take a holistic approach when you're sitting down with the parties and map out a broader canvas, if you will. Step back and realize that these people may be doing things that you would usually expect in a classic mediation, but they're exaggerated. So whereas somebody might have a real problem with their management team back at the factory or back on the floor or back in the partnership, when they come to this, there are a lot of other pressures that are quite immediate and looming, and they aren't able to even step out of the house. We often talk about mediation, about getting people to a neutral venue, getting them out of their usual surroundings so that they can be a little more relaxed, a little more arm's length from what's going on. That is not the case with virtual. They are in the soup, their kids are next door, so is their partner, lover, wife, whoever, and they have to deal with it. So the question is, how do you deal with virtual mediation? What do you need to know as you're going through this? So obviously these ever-present features are there, and there's going to be consequences and you have to deal with it. But remember this, without that proximity to build that trust and the goodwill that you would usually do through modeling, you have to find ways to achieve it anyway. So you have to do the same as you always do, but slightly tweak your approach. So while some of you may have experience with mediation, never forget that almost all the parties have zero experience with virtual mediation, zero. And that means that they are not as comfortable, as relaxed, and as in the groove as they ordinarily would do. So as Richard said, invest the time in the virtual opening statement, don't rush. This is your chance to establish rapport and trust. And don't forget, because they have zero experience, they are looking to you for guidance more than they might in regular mediation. So use this first clean shot you have to make your point, to set the tone, and to establish the type of behavior and interaction you want. The other thing is you're going to have to use caucusing. Some of you may over-rely on caucusing. You can't, because this is an issue unto itself. Those of you who either don't use or overuse will find that they have to adapt to virtual mediation, which means you have to remember, when people are stepping out next door in a law firm or an ADR center, they're having coffee, biscuits, and they're just relaxing and what have you. But they're unable sometimes to even leave the room in which they're doing this mediation. Because if they leave the room, a child might come in or a family member might come in. So you'll have to really check in and address underlying fears that they might have. You're also going to do a lot more verbalizing. So you're going to have to put into words what you see on camera. Because people are feeling awkward, and all the research over the last 20 years on virtual mediation does support this. There are a lot of algorithms at play with some of these technologies. Even now, you can't see all my expressions. They actually get played down, the lighting and all the rest of it. So there are technological aspects to what you're doing. Now, the other thing is when you're in there, just remember what your job is also to create breathing space. So the good news about virtual mediation is that's built in. You're not likely to be able to do marathon mediations. People simply lose focus and they become overstressed, overtaxed, and they have other imminent issues like getting a child out of one grandparent to another grandparent, what have you. So with that, use this space that you're created. Yes, you're going to lose momentum as people move between sessions. That's a fact. But what you can do is allow this to give them time to breathe and build in the fact that what you want to do is have shorter, more frequent sessions. And you also want to be easing the tension, and you can do that. And use the time to add value. Give the parties homework. Often in mediation, you find out that a document was missing, a party was missing, and that something else had to be done. So fine, since you have these breaks, task people, get a consensus about who's going to do what between which sessions, who's going to provide what, and maybe add a party, add a manager, add a coworker, whatever it might be. Now, as for the case, you have to remember, often in mediation, the parties are using digital files. Now, on the one hand, that's a positive. It means that Richard or Mark or Paul or Chris cannot say, James, I don't have access to that. Of course you do. In fact, the mediator can say, well, it says here you opened the file, and so I know you have the file. Would you like a break to review it? So it's good for continuity. It's good. You can even work off live documents and edit them. That's all good. But don't forget this. When people are reading something, you don't know what they're reading. None of you know that I've been reading The Economist and the Financial Times throughout this entire session. And so you don't know what I'm reading. Whereas in a mediation, I look over the corner of my eye and I see Mark is actually looking at the actuarial chart. And I look over at Richard and he's looking over the annual report. Now that's good news. They're both topical, but they're not what I'm talking about. I'm talking about something altogether different. You lose that in a virtual mediation. So what you can do is share a screen. You can focus people's attention. There are tools there to do that. So use the tools, be aware of this. And if you see people's eyes are down, you may literally have to ask, Richard, are you reading the report, the annual report from 2016? And Richard then says, no, I'm fixated on whatever he's fixated on. So this checking in and making sure that we're all doing the same thing the same way at the same time is very important. As for the case for virtual mediation, here's the point. The biggest challenge, obviously, is adjusting for the mediator and getting the balance right. That we have to do. We don't want people overcompensating for things. But when you're going to pitch mediation to clients, remember this. All major ADR providers have said that they've reported growth. The virtual mediation is booming and they expect to be steady over time. What the long-term picture looks like is to be determined. Yet one would have to think that various stakeholders, right, are not going to go back to the way things were. There's going to be change. We're not exactly sure what it is, but one of the things is the perceived benefits will likely be very powerful in those who've experienced it over this period of time. Specifically, the cost savings are going to appeal to companies, shareholders, individuals, courts, and governments. There's a reason the UK courts have gone virtual. There's a reason the Supreme Court today is for the first time allowing people to actually listen in to oral presentations. So what happens with this perceived progress? So you're going to have to think that with all these traditions being broken, all these companies taking advantage of these technologies, this is the new normal. This is what people are going to do. And even if things go back to normal, so-called to traditional classical mediation, there's going to be a lot of pressure to use what was put in place over the emergency, to use the rules and procedures. And the people, for example, on this call are going to use this and what they're learning from these other webinars, how to apply it. So if you don't need courts, and you don't need hearing rooms, and you don't need to pay for arbitration or mediation rooms, why pay for them? So there's going to be a lot of people asking these questions, and there's going to be people who want to do mediation in their underwear and so forth. So what you have to decide is, how do you as a mediator want to participate in this? And what are you going to do in these to transfer your existing caseload of face-to-face to the other? So right now, all of you need to ask yourself, how am I going to take this as an opportunity to develop my practice, my existing cases and clients, and how am I going to grow the pie? And how am I going to pitch it? And I think that there's no question that people are going to be saying to themselves in the future days that, you know, this is a game changer. All of you will remember or be able to read about decades ago, there were challenges for us trying to promote mediation. But why? Because lawyers opposed it and various other people. Those same lawyers have become, over the interceding decades, the very champions and themselves the mediators themselves. So people have changed the way they view it, they have bought in, and they've started to use it. And if you travel the world, there's a lot of people who used to be against it who are using it. So the final question really is, what are you going to do as a virtual mediator moving forward? And even if things change sufficiently to allow face-to-face mediations, there is going to be enough impetus and momentum, I submit, that people will want to persevere and continue using virtual mediation as a solution. And I really would love some questions, so I'll stop here.
Thank you so much, James. Any initial reactions from our co-panelists?
I have a number of them, actually. I just saw an excellent question, which was, you know, how do you caucus when you're doing a virtual mediation? It's relatively easy on this particular technology on Zoom to set up meeting rooms and meet with people individually in those meeting rooms. As a host, so as the mediator, I control who goes into each room. I can bring them into my room collectively. You know, I use the process as is necessary, but you can do it that way. Let me pick up on a couple of other things. I want to second what James said, and it was very much in this article about shorter. Those of us who've been mediators for a long time are used to the marathon, and people get reasonable after 8 or 9 hours. But the truth of the matter is, in a virtual mediation, you really can't do that. And so we're looking at a significant change in terms of process, more mediation conferences, a shorter duration. Maybe it'll make for better outcomes. It may make it also, it'll certainly make it different. But shorter meetings, I think, work because you cannot hold someone's attention for more than a couple of hours online. Finally, I think it's very important for us to remember as mediators that relationship building is still and trust is at the heart of the process. And when you're online, one of the ways that you can do that is by doing an organizational meeting up front. Many of us do that as a matter of course anyway, but I think organizational meetings are going to really become more important. Not only will they give you an opportunity to sort of work through the technology and who's comfortable doing what, but they also give you a chance to sort of get to know each other.
I would say, in terms of the phrase used by some Dutch mediators that I've been speaking with, is fewer, shorter, and closer together. So it's, in order to keep that momentum, what you'd want to do is to schedule the mediations consecutively. So maybe Monday, Wednesday, Friday, or Monday, Wednesday, Thursday, so that you get the advantage of breathing space, but you don't lose the things that were uttered. You don't have to keep restarting, as it were. So also, it's I characterize it recently as a series of sprints rather than a marathon. And I think that the reason that is applicable is it is just as much work to do 3 sprints as it is to do a marathon. And there's a lot of prep that goes into that. And it's not easy going. But I think that in terms of these people around the table with the caucusing that Mark referenced, don't forget, people are not very keen necessarily always to caucus because they fear what might be said without them in the room. But I guess you're going to have to find basically what works for you as well as a practitioner, as a mediator. So you may have different users in different countries and different cultures who do things and have slightly modified expectations. I'm always an enthusiast for making things as universal as possible, but being responsive to the immediate needs of the parties in the given cultural context. So if you've got a lot of people who, are asking for the same thing, you just have to verbalize. You just have to explain to them what the information they need to make that choice is. So you explain to the parties, if we wait another week, and so on, and you explain the pros and cons, and they will usually, I find, be practical, pragmatic, and respond accordingly.
Christian, I've just seen a question, if I may, which is going to pick up on what Mark said, because I would have liked to have answered the same question that Mark did, but he dealt with it. My response on the webinar chat was that it's a technical problem which can be overcome, as you quite rightly pointed out, by having the different caucus rooms. So you would put the parties into each room. The question which has come to me is, would a virtual mediation cost similarly to a regular mediation? I'd like to answer that one immediately, please, because my comment is going to follow what James has said, and that is the timing involved. We've all done marathons, believe you me. I did over 20 hours on my ICSID one. It was a true marathon. The problem is that virtually you will not get, no mediator will get the parties' attention for that period of time. And the parties are going to lose their attention very, very quickly. We held, for example, the 90-minute prep. And I have to say, I was exhausted after 90 minutes. And I expect all the attendees here to be pretty tired as well. That's going to be an advantage because it focuses the parties' minds on what they're actually doing there. That's number one. And in that focus, it gets rid of the grandstanding, which some lawyers, not everyone a lawyer, but some lawyers like to do, which is often a waste of time. Sorry to the lawyers out there, but grandstanding in a mediation really does spoil the process. And so by having a much shorter process, my suggestion to the questioner would be to the question, would a virtual mediation cost more or less? I think a virtual mediation should cost an awful lot less. And that's got to be one of the advantages. And in fact, it's what COVID-19 has done for us. Because I often say to people, out of evil comes good. Thank you.
Thank you very much, Paul. Any thoughts from you, Richard?
Building on what both James and Mark said, I think in the caucusing need, we will find an increased use of what I called asynchronous caucusing. In other words, it will get awkward online, as it is in person, but more so online, to do long caucuses with one party while the other party is cooling their heels, as we say. So I think what will become a much more common practice is to have the joint session, to keep the joint session going as long as possible. So not breaking too often for caucuses unless absolutely necessary in the minds of the mediator. And then scheduling different times for caucuses, but before breaking, having a clear schedule so everybody knows when each of these caucuses is going to take place and when they're going to reconvene.
I would also say that typically you'd want to schedule them in the morning when people are fresh. It also lets you reconvene later that day. But one of the challenges around this is during Ramadan, many people would rather do things very, very late at night in the Muslim world, particularly the Gulf and the Shams region and so on. So I think that post Ramadan and elsewhere in the world, I would suggest mornings if possible, as long as that doesn't force people to the middle of the night if they're in the wrong time zone. But also it lets them reconvene in the afternoon and hopefully keep things going and maybe settle it in a day, depending on the dispute. Also, because of the less expensive nature of this whole exercise, as Paul alluded to, don't forget, this is going to mean that as people get increasingly comfortable, the scope and the types of disputes that now become viable for a mediation process increases. So you can actually do smaller claims because the actual cost and the transactions, the overhead and all the rest of it are not extortionate. So, and it also helps for people who are either disabled, socially isolated, or in disparate geographical locations. So this is a very flexible tool if it's used properly.
I guess if I may jump in here, one of the questions is, of course, is the technology holding up? I think this webinar is living proof to it, yet we can discuss further also what happens if. But I think one of the elephants in the room is that is also coming here across from the webinar chat and the Q&A is it as effective, is it as efficient, as successful as classical mediation? Are settlements coming out at the same rate? Is perhaps early to call. But what are your respective perceptions as to whether or not virtual mediation lives up to the dream that we all can, as you said earlier, mediate in underwear and still settle?
I think that remains to be seen. I mean, we're at the very early stages of this, although within the mediator community, there are an awful lot of mediators who are already developing experience with the process. So I think we'll know shortly. And I would venture a guess that the settlement rates will be at least as high. That's my guess. I don't know what the others think.
Well, we do have online mediation in the UK on very small cases, and that's got a pretty good success rate. So I think that this virtual mediation is going to follow on from that. But as you've quite rightly said, and I've actually done a chat answer to the questioner here, it's very new. So I'd love to hear what everybody else has got to say.
Any further thoughts on this?
I can tell you that telephone mediation has been going on for decades in different countries, used for automobile disputes and all sorts of other insurance and other matters. Because when you've got somebody who's a 10-hour drive north of a major center, it's not really viable to come into town over a $15,000 car accident or whatever. So I think that if it does work as it does in the UK, as Paul said, if it does for the phone mediation, and if it is working this way, historically, most of us, I think, have used virtual mediation as a follow-on So you've had 1 or 2 sessions, the parties have to go back to their various parts of the world, and you agree you'll have a video conference to close the gap or to go through whatever's pending or update each other and then ink the deal. So it has a long record of as a closing feature. The hard part is that first few sessions. And I think if you can do those reasonably well, I agree with Richard. I think the settlement rate, and certainly that's what everyone is reporting, is quite good.
Do you feel that, Mark? Go ahead.
No. I was going to add something slightly different, only because I saw a question. We're dealing with an imperfect process, and the technology is still developing. And there are articles out there that deal with a question that was posed to all of us collectively, which was, do you have a special sort of confidentiality protection with Zoom? And I will tell the questioner, I do not have a special, agreement with Zoom. There have been articles already published in the trade journals regarding what you can do around sort of workarounds, confidentiality issues in terms of your clauses, in terms of accessing the process. But there's nothing perfect. And, we have to take special steps, I think, as mediators to protect the process. Some of that is just making sure we know who's in the room or who are in the rooms and getting commitments from parties. Again, I think we can deal with a fair amount of that through our access, through our agreements to mediate, and through procedural rules that institutions like SCCA will put in place.
I was recently in a conversation with a Saudi mediator, Rosanna Al-Tayyar from Jeddah, and Mohammed Al-Nasser, Judge Mohammed Al-Nasser, who's a good friend of everybody in this call, also a mediator colleague. And this question about what happens if someone abuses, because people may be willing to, say, not remove their niqab and be in a hijab on a video. What if somebody uses inappropriately an image, a still or a video? And Judge Mohammed reminded us that there are already provisions in place in most of the GCC countries and elsewhere for unapproved, without permission usage of images of individuals. And there are actually protections at law for people who that are in place. And so this idea of abusing confidentiality and so on in images is one thing, but I'm not really worried so much about that necessarily, or even people releasing video, as much as perhaps leaking an image more to shame a corporation or to out an individual. And that's not necessarily as prevalent yet in the Arab world, but trends are trends. And so I would be wondering what any of you think about the possibility or what can be done. Obviously, you have people sign the agreements. Obviously, there are ethical considerations. But has anybody heard of how people deal with this issue of naming and shaming, something that's emerged in the mediation context?
Can I come in on that? Because mediation, forgive me, so sorry, Richard, very quickly, and then I'll pass to you. Mediation is meant to be confidential. In fact, some of the questions that are coming up on the chat refer to this, and there's one about recording a meeting. You need, for recording a meeting, you need every party's consent to this, and preferably, and this would be my advice, in writing. Now, the naming and shaming is frankly, really, I would regard it as bad faith. The whole point of a mediation is to enter into a structured negotiation in safe and neutral circumstances with a view to arriving at a settlement which can be kept confidential. I'm sure Mark will agree with it. I'm sure the entire panel will agree with it. So naming and shaming is maybe great for one of the parties, but what does it achieve? It actually alienates the other side, as a result of which they're unlikely to come to an agreement. So what has been achieved?
If I may, I wanted to switch gears a little bit. There was a question about the loss of the cues from body language online. Yes. And how much that inhibits the ability to get settlement. There's a lot of talk about that, and it is true to a degree. You have fewer cues to work on, but there is not an absence of nonverbal communication. human beings at the most basic level are extraordinarily good at perceiving unspoken messages, not necessarily hidden messages, but just the color of the ambiance from the other parties. And as we do more and more online, we're going to very quickly become much more sophisticated in intuiting, sensing, observing the nonverbal communication. You get a lot through the face and the head and the pauses and the timing. So it's not all about reading body. It's more the totality of the people you're communicating with. I don't think it's as much of a handicap as people say.
And I guess adapting and evolving is one of the themes we also cherish here in this webinar, since we're in the midst of the general discussion at the border to the Q&A section, which we already have been doing for the last 20 minutes as well. But one of the questions that came really up quite frequently here is about you have a settlement agreement, and now what? Is it what happens if the other side walks away from it, doesn't honor the settlement agreement? It's basically just another breach of contract, and it brings you where you started off, perhaps in a better position. But nonetheless, you may end up again in court if you don't have an arbitration or mediation agreement actually in the settlement agreement. Finally, the Singapore Convention was mentioned in a couple of questions. Any thoughts on that and how to look at this instrument as something that can help in the future?
I'll just say very quickly, I think the Singapore Convention is a wonderful addition to our, to the field and to mediation generally, for lots of reasons, not the least of which is it addresses sort of uncertainty, and even if it's not necessary. And I think in most cases, enforcement is not an issue in mediation. That's been the history of the process. But knowing that there is a vehicle in place for enforcement just makes it easier for people to participate. So I think it's changed the climate a little bit. So I'll say that. There are also there have always been ways of enforcing mediated agreements. So incorporation in a consent award of arbitrator is one way to do it. The other is, of course, if it's a matter of check and release, we're not closed until the wire is received. So some of this is just commercial know-how, and you'll get the agreement when I get the money, or we'll find a way to exchange it. But I do think the Singapore Convention is a terrific addition to the process. Certainly is going to help. I think it's going to help us going forward.
Yes, essentially what the Singapore Convention does, in my mind, is emphasize the seriousness of mediation. And that may be, in fact, a big advantage for online mediation, where some people may think it's a junior member of the ADR process. This changes that. For those of you who aren't familiar with it, Singapore Convention essentially provides that countries which sign on to the convention say that a mediated agreement, a settlement agreement, is enforceable in the local courts. And this is modeled after the New York Convention, which does the same thing for arbitrations.
I will say one thing about mediation and enforcement, as just riffing off what both the last two speakers said, is this, that I very rarely, mediations sometimes don't settle, that happens, but when they settle, they get implemented if they're done right. And that's part of the mediator's job, is to make sure that what is being reduced to writing reflects the intention of the parties, is implementable. It doesn't have to be a sure thing, but it has to be possible. And that's part of the mediator's job, is to make sure that if Richard is offering 50 million in caucus, I might ask him, how he's planning to do that. I understood his company was recently evaluated at $100 million. You're going to pay $50 million to settle the dispute? That's
but I don't have authority to settle that.
Can I mention something? I'm thrilled that we have experts that are actually listening to this program. I just saw somebody remind me of something I knew perfectly well, which is that one way to handle this parties in different places and certainty in terms of payment is to create an escrow or put monies into escrow and allow for those monies to be distributed at an appropriate point. So well taken, and good for you for paying attention.
Absolutely, absolutely. I mean, a mediator's job is, if there's going to be a settlement, to encourage the parties to actually enter into a written contract. Now, that's a classic mediation. So I'm taking us back to James's theme. Real question is, how are you going to do that in a virtual mediation as we are now? And the answer has got to be, we've got PDFs that we exchange signed agreements done by a PDF. So once you've got the signature of the authority on that document, then you can take it to a court. Now, if it's done locally, that's great. If it's international, it's another story, which is one of the wonderful advantages of the Singapore Convention, which, as Richard has said, is modeled upon the 1958 New York Convention. And I think that's got to be the great advantage of the Singapore Convention. It's brand new. This is all brand new. And this is so relevant to what COVID-19 has done for us. It's forced us to think, how do we get a settlement? Number one. Number two, how do we record it? How do we arrange for it to be the right settlement, that it's possible? And number four, how can we enforce it? And that's why I'm going to support what my friend Mark has said. I'm so pleased that there are so many good practitioners listening to us, because you're the guys and ladies who are going to have to do it.
Speaking of our learned panelists, one of them, Rad Al-Mansour, mentioned even here in Saudi Arabia, the settlement rate in ODR for small claims under 6,000 USD is more than 60% settlement rate. And this rate is based on that issue by the Ministry of Justice of Saudi Arabia. So even in the kingdom and in neighboring countries, in various formats, including ODR, there's been very good traction and very good results.
Excellent. So I hear that enforcement is, of course, on everyone's mind, particularly in times when the courts are overwhelmed with what's going on in some jurisdictions. They even have shut down completely. And while even courts try to go virtual to some degree or not, there's always the issue when you have a settlement agreement, will it be honored? If you have an arbitration, it has to be enforced. You still need court activity in some sense. Do you see any opportunities for institutions to help parties and the court system?
In terms of virtual mediation, don't forget, Saudi Arabia, I know Chris knows this because he's administering the said program, but there are Ministry of Justice mediation programs underway where they're having good traction and good results. Judge Mohammed Al-Nasser, the fellow I mentioned earlier, was very active years ago when we were setting up the court-connected mediation programs in Jordan. So there are a lot of, there's even mediation programs in Morocco and elsewhere. So there is a good underlying long-term awareness of mediation, but it's still only nascent in many respects. They haven't yet gone, the use is fairly limited to whether it's divorce cases or whether it's small claims, or depends on the country. There's also programs in Oman and elsewhere. But I think to take this to the next level, I think a big part of it is a lot of education, webinars, a lot of engagement, and helping people see the efficacy and the utility and the applicability of these disputes. And I think that the ADR centers in the Gulf and North Africa and elsewhere have to really continue full on with engagement with government officials, with corporations and others. So that's why it's really important that everybody continues to do this. And I think that individuals who have links to companies should reach out and do their own webinars. Some of the mediators in this call may decide to do a webinar with a given entity or corporation or association or professional body. I know SCCA is doing them with the Saudi Lawyers Association and others. That's really, really important.
Yeah. Just very quickly, I mean, I would be remiss if I didn't mention the International Mediation Institute. There is something to be said for quality assurance and institutions, so an SCCA can provide that to government. I think that's why government works frequently with NGOs, because NGOs give that sort of a stamp of approval. They create a process, and they both for the parties and also for vetting mediators, that gives confidence to judicial administrators in terms of taking their own programs forward. So, Chris, the answer is absolutely yes.
Chris, might this not be the appropriate time for you to do 2 or 3 minutes on the SCCA's program, because I think it's been quite impressive.
I was trying to find the bridge, and thank you for pitching it. Indeed, one of the things that the SCCA has been thinking loud and hard about over the last couple of weeks is how we as an institution can assist parties, the businesses that are suffering due to these trying times, COVID-19 times. So what has, or is about to launch, I should say, we're really talking about days at this point, is a new program. We call it the SCCA's COVID-19 Emergency Mediation Program, or in short, just EMP. EMP is what should resonate better. The idea is really to have a very fast and effective mediation for parties that are in desperate need. Think hospitality, travel, even at the mall, you don't pay rent anymore, yet your business is down. So all those industries that are really suffering from this the most, to have fast, effective mediation, it's all done online. It's comes in as a reduced fee schedule. And perhaps what makes it really fascinating, and it's, as to my knowledge at least, first of its kind among institutions, is to have the possibility to convert that settlement agreement into an enforceable title. That is a bond. I repeat that. To have the settlement agreement being converted to enforceable title, a bond, which means in Saudi Arabia you can go with this document, with this bond, straight to the enforcement court, thereby bypass everything that you usually encounter when you have issues with another party not honoring the settlement agreement, which again is nothing else but a contract otherwise. So again, you can convert it into enforceable bond, which gives you a lot of power leverage and a lot of certainty, legal certainty that parties need so much in the process to move on with their businesses and trying to rebuild basically as the pandemic hopefully will wind down at some point. Any thoughts about this? It's again brand new stuff. We have at the end a slide that will show a little more detail about this, the takeaway points, if you will. But any reactions to this kind of programs?
One quick thing about that is to address Paul's question about signing. One of the features on this program is going to be an online signature that is recognized by the courts, by the governments and others in the region. So the signing of the document and the guaranteeing of the authenticity of said document is addressed. The identity of the parties is addressed in the registration process. That's very important as well. And for example, there will be issues about how do you identify somebody who you can't see their face, and so on. So, but these are all addressed. And then with this real innovation that Chris is outlining, the conversion to an executable title or bond is extraordinary and very powerful. But obviously the parties should always know that that only happens when they agree. So until they agree, this is just another negotiation. It's when they sign off that it becomes enforceable. But Chris's team has done an incredible job of developing this program, and it's been remarkable to see how this is going to work. And there's a lot of good information available on the SCCA website. And also there's also been some announcements about the involvement of different sectors and different entities in the kingdom being involved with SCCA. But this activity, I think all the centers around the world have pretty much tried to offer this sort of a program in terms of virtual mediation and virtual arbitration. And SCCA has done an excellent job. And Dr. Hamid Al-Mirra, the CEO, Chris Alberti, and others have done an incredibly good job. And the team there is really fantastic, I have to say.
Agree. I totally agree. I mean, this is cutting edge stuff. You know, the Singapore Convention has not quite led the way, it's shown the way. And frankly, I think the SCCA has done a tremendous job. They did a tremendous job with their arbitration rules in February last year. And this this innovation, frankly, I think is going to solve a great many problems in enforceability. And that's where mediation tends to fall down when you get this, when you get problems with the actual signed, if it is being signed properly, mediation agreement, where it might not be quite accurate or reflect what the parties have agreed. I've got one on at the moment where there's an enforceability issue here in the UK. I think the SCCA have done a superb job, and congratulations to them.
Any other reactions? Mark, have you seen anything else, or do you have any other advice? What else could be done to help mediation, give it more teeth, if you will?
No, I mean, I heard James's point about the parties need to reach an additional agreement in order to have the enforcement mechanism apply. But you know what? That's the process. And reaching an additional agreement, that's just making sure everybody, all the I's are dotted and the T's are crossed. You know, so to me, that's not a big deal. That absolutely should be part of the process. It frankly is one of the things that I think one of the exceptions for the Singapore Convention is that a state can sign on and say that it won't apply unless they agree at the time of mediation, you know, which is fine. It's pretty much the same thing. It just means before we wrap up, you know, I want to make sure you agree that this settlement is going to be enforceable. So I don't have a problem with it at all.
Indeed. I am cognizant of the time. We're slowly moving towards the 90-minute mark, and I want to give everyone, before I give perhaps some closing remarks, an opportunity to perhaps say some final comments. We have been covering a lot of questions. It's not always easy. I haven't seen any live questions. Everyone has been very proactive in writing down the questions, which I am very appreciative of. So we could pick and choose, depending on where it fit best in our presentations. But any final comments from all of you? Who wants to say the final words before we all go to bed or have our first coffee?
Well, one of the people asked, what happens in case inspection of physical evidence is necessary? The originality of documentation is questioned to enable virtual mediation or arbitration. Will documentation software be mandatory? And so from commencement of the contract. I can say that in a number of ADR centers have these 3D display cameras that enable you to actually show people remotely, you know, like a broken pipe or a particular item, and you can actually do that. So depending on what happens with COVID, it may be that things are shipped, allowed to be a sufficient time for the virus to die and so on, and then these sorts of technologies can be used. Because in Bahrain, they had the 3D camera, which was very useful when people are off site, to hold up a broken fragment, and it gives you a very high definition, high res look. And then the engineer can notice striations, can notice this and that, and can ask them to measure something and all the rest of it. So there are ways to get around that. But what other ideas do people have about physical presentation and virtual mediation?
Thank you so much, James. In the final 2 minutes, any final comments from our other speakers?
I would simply say thank you for your patience, and we hope to see you all online soon.
Absolutely. Looking forward to it.
Me too.
Oh, wonderful. Well, we have come to the end of our 90-minute session, and I have to say, I'm very happy to say that we were able to cover a lot of ground despite the time constraints. 90 minutes passed by so quickly. In the end, I think it's fair to say that we have accepted the challenge, even at its institutional level, and have adapted to the new realities. And while we all hope that the impact of the pandemic will soon slow down, it is not a showstopper. Mediation will continue, we always will survive to what we do. And we just have to do it a little different to make it work for us. So again, ladies and gentlemen, our webinar series continues this Wednesday in Arabic in partnership with the Saudi Bar Association. So please join us if you can, again, this Wednesday. For now, I would like to thank our wonderful speakers for this lively discussion and for sharing your profound knowledge and amazingly thoughtful insights with us. I also would like to thank our attendees. I think we were hovering around 160 attendees at some point, which is quite amazing, I should say. Again, we will shortly publish this webinar on our website at www.sadr.org. EMP. EMP stands for Emergency Mediation Program, EMP. And we also invite you to contact us to learn more about the SSC and our services, of course. And until then, I wish everyone a good morning, a good night, wherever you are. And I hope to see you soon also in person. That is hopefully something we will be able to accomplish at some point. So again, thank you everyone, to the audience, to our speakers. Wonderful night with you. In my case, out of Dubai.
Thank you. Bravo, Chris. Thank you, everybody.
Thanks, Chris. Thanks all.